My name is Joe White. I'm the director of the Center for Policy Studies here at Case Western Reserve University, and it's my great pleasure to welcome you to this Global Currents lecture by Professor Susan Sell. The Global Currents lectures are very kindly funded by Ms. Eloise Briskin, and we thank her for that. I would also like to thank the Associate Director of the Center for Policy Studies, Andrew Lucker, for all his help in things like recording and organizing and publicizing and everything the Center for Policy Studies does. And I would also especially like to thank Samantha Hill, the Department Administrator of the Department of Political Science, for the administrative work she does for the department and for the Center for Policy Studies and many other people, and particularly in helping organize this program. We like to have timely programs. A program on the politics of international trade and rules about intellectual property is rather timely today, because today the negotiators announced agreement on the Trans-Pacific Partnership Agreement in the negotiations down in Atlanta. I'm not sure why you're negotiating anything in Atlanta, but so it goes. But this is just the latest installment in what I've referred to as a 30 years war over intellectual property in international trade. It's probably longer than that. But some of you surely are aware of some of the conflicts over things like the Doha Round and the treatment of drugs and the availability of generic drugs for AIDS. Another more domestic battle involved the attempts to pass piracy legislation, internet piracy legislation in 2012, which crashed and burned in a really dramatic and surprising manner, which generated the original title for this program, which was Revenge of the Nerds, which is how Professor Sell described the victory of the pro-piracy forces. I'm not sure how to put this.
No.
Of the intellectual freedom forces.
First Amendment forces.
First Amendment
Privacy
forces. Privacy forces in January of 2012. To address this is an extremely timely issue, it's really wonderful to have Professor Susan Sell of the George Washington University Department of Political Science and the Elliott School of International Affairs here to speak today. Professor Sell has written numerous books and articles on this topic. This includes Who Governs the Globe, a co-edited book in 2010, Intellectual Property Rights, A Critical History in 2005, Private Power and Public Law, The Globalization of Intellectual Property Rights, which was published in 2003. But if you want an update on that, you can get the Korean copy, the Korean edition, which was published in 2009 and had some additional material. It has also been published in Chinese, which is an indication of the extent to which Professor Sell's work is taken seriously around the world. And I think I will leave it at that, because she has a lot more to say on this issue than I do, and it's my great pleasure to introduce Professor Susan Sell.
Thank you very much, Joe. I first met Joe when I was extremely wet behind the ears as a graduate student at UC Berkeley, and he was already there, so we go back a long way. Anyway, I want to thank you for inviting me here. I'm really excited to be here. It's very rare that in an academic talk that you could say is actually ripped from the headlines, but today I can say that, and so I'm going to just say it, because you don't get to do that very often, because today they announced they have a deal on the Trans-Pacific Partnership, which is part of my talk today. But what I want to give you really is a larger strategic framing picture about how all this came to be. I want to talk about how issues get framed. I want to talk about this dynamic process, because these negotiations, the way I see them, they're never really over. They're not a one-off where it's over, we figured it out, but rather I'm interested in the way actors frame the issues, the strategic use of various institutions, both multilaterally and below that level, regionally, bilateral negotiations, and then how the cycles of interaction and contestation change at each iteration of the game. And so I'll be telling you about how we got to TPP. I guess that's a short way of saying it, and hopefully a lot more else. Okay, so first of all, I think it's important to point out that intellectual property is a weird term. It's not really property. It's not really an intellectual property right. It's not really a right. What it is a state-constructed temporary monopoly in order to try to incentivize the creation of useful material. We have a rather utilitarian version of it, but they're really intellectual monopoly privileges is another way of thinking about it. They're not rights like a hammer. If I have a hammer, you can't use the hammer till I'm done with it, then I hand it over. But with my ideas, we can all use them at the same time. And so in order to create incentives to create new things, the state steps in and gives temporary monopoly privileges in order to give people incentives to create and to disseminate the rewards of that creation. So I like to think of intellectual property as really a public policy. We can see historically there have been really shifting conceptions of what counts as property. So I think of them as temporary monopoly privileges created by the state to serve public policy goals. Early letters of patent in the United Kingdom, they didn't reward the inventor, but they often would reward the person who imported a technology into the kingdom. If you were a Venetian glass blower, and you didn't invent it, but you brought it to England, you could get a temporary monopoly privilege. You would get a letter of patent, and you would have exclusive rights to make, produce, sell, license, whatever that technology. The same was true with salt making. So dependent really on your stage of development, intellectual property can be seen, or intellectual, depending on your stage of development, what we call today counterfeiting in the United States can be seen as theft, or it could be a public policy in order to promote some other social good. So piracy, what we call piracy in a very pejorative way in the United States, has been historically an important tool of social policy for the public interest. One example of this is the United States refused to offer copyrights, recognize copyrights in any foreign literature. So the United States had the public policy goal of trying to create and promote an indigenous literature and also to get a literate population. They wanted to get good English writing in the hands of the population so they'd be interested in learning how to read. And so what we did is not recognize Charles Dickens' copyright that he owned in England. And so we would just crank out his books for pennies a book and with the penny presses and just give them to people or sell them very, very cheaply. So there's wide access to this really great literature. And that was a public policy goal because we wanted to promote literacy. Another example is our land-grant universities. I'm from Minnesota, and the University of Minnesota was established as a land-grant university. And what it used to do is give away seeds for free because it was trying to attract a population to come west, create, clear forests and create arable land to help feed a growing population. Now, when you think about patent rights in seeds and Monsanto, it's kind of hard to believe. At once our public policy goal was designed to give seeds away to get people to produce and feed a growing population. So depending on your historical stage, what your public policy goals, your mix of the kind of things you protect and the kind of things you don't protect will really vary. And if you think about it as a public policy. So some of the public policy, so these have changed, or temporary monopoly privileges, stages of development. So what are some of the public policy goals? They're to attract and retain skilled artisans to your territory, which was really an early one. They are to help develop agricultural capacity. They're to encourage literacy, as I mentioned. Sometimes it's to provide jobs, promote public health, and also to promote innovation through access. And there's a lot of economists of innovation these days. There's a huge literature coming out by economists of innovation saying that our system is broken and it's gone too far. And too many property rights have been choking off innovation. And so access to the fruits of intellectual property is problematic. When 100 people have patents on one piece of technology, it's really hard to negotiate with 100 rights owners to try to, build upon that innovation. So, but you might want to promote innovation through granting access to that technology. So who makes intellectual property policy? I'll go back to the 70s and the 80s because this is really the root of where all these politics I'm talking about today were born. And who made intellectual property policy in the United States? It was Walt Disney, it was pharma, Microsoft, and other kinds of property rights owners. And they were very concerned, as was the United States government. They were concerned that other countries were stealing our intellectual property. You hear this a lot about China these days, that other countries were stealing our intellectual property and they were not really getting the full value of their innovations. And so they needed the government to help them get enforcement of intellectual property rights. But since many other countries did not have the kind of rules we had, they needed the government to negotiate for other countries to adopt policies that would protect American-held intellectual property rights. At the time, the United States was reeling under twin budget and trade deficits. So we were worried about trade. We had, the declining industries. And these particular industries actually had export surpluses. We were exporting more pharmaceutical goods than we were importing. Same with Hollywood, movies and TV and stuff like that, and software. So these firms were able to convince the US government, and particularly the Office of the US Trade Representatives and Congress, that they were part of the solution and not part of the problem. So you really need to pursue our policies internationally so that we can help the American economy rebound. We create jobs. Our industries are competitive in world markets, and you should support us. So the story of the uptake of wanting to protect intellectual property abroad and spreading this approach to other countries comes from the insights from Mansur Olson's collective action. That when you have a small group with large resources and intense interests, they are often able to get their way. So these firms and others, including Monsanto, agricultural biotechnology firms, DuPont, there are a number, but these firms had a very intense interest in getting maximum intellectual property standards globally. That's what they were looking for, and they would be able to profit from that. So small groups with large resources, intense interests in maximal IP were really able to shape the policy dialogue and policy itself. So Congress passed particular laws that required other countries to adopt stricter intellectual property policies. We engaged in a lot of bilateral negotiations. We adopted trade policies that allowed us to name and shame trade partners who were not protecting our intellectual property. And in the case of the costs of not having protection and the benefits of getting maximum protection were highly concentrated among this group. But large groups like consumers, they're not really likely to mobilize against this, and the costs of collective action are high, the benefits are diffuse. So this was really a classic collective action story of these firms that had high value-added intellectual property to shape public policy in a way that would promote their interests and allow them to get more returns on their property rights. And what they did, which was quite ingenious at this time, is they redefined intellectual property as a trade issue. It used to be thought of as a property rights issue, more recently, the 60s and 70s, but now they said, no, this is a trade issue, and we have surpluses, export surpluses in this, so we need to think about intellectual property as a trade issue. So with that background, I'm going to identify the cat and mouse, and then I'm going to walk you through all the different strategic institutional shifts that they've pursued over the years. So this is a complicated story, so I'm oversimplifying it, but who they are. The cat, Tom the cat. And who is Tom the cat? Here, representing industry associations, representing intellectual property owners, multinational enterprises that have intellectual property as a big part of their portfolio, United States Trade Representative's Office, the Organization of Economic and Cooperation and Development, and World Intellectual Property Organization. What do they want? Their goal, the CAT's goal, is to ration IP, to make it more scarce, so they can get a higher return on their investment. And what do they want? Or what are the characteristics of the CAT? The CAT's larger, stronger, and has more resources. This is describing the situation in the 1970s and 80s when there was this big collective action domestic push in the United States to get the United States to lean on our trade partners to get them to adopt higher standards of intellectual property protection. So the CAT is one actor in this story. The second one is the mouse. And who's the mouse? This is Jerry. And the reason I like Tom and Jerry, because I'm talking about form shifting, is they run after each other and they don't stop running after each other. So this is very much a process I'm talking about. It's a dynamic process. I think it's dangerous and misleading to look at negotiations as one-off and say, oh, that person won, that person lost, because as I said, they're never really over. And so Tom and Jerry captures this. They all live to fight another day. And that's very much the story in this policy space. It's not like Itchy and Scratchy where the cat blows up and it's dead, but Jerry and Tom keep chasing each other around. So who does this represent? Developing countries, non-governmental organizations, like Doctors Without Borders now. Some firms could be characterized by the mouse. Generic firms, computer equipment manufacturers, and lately IT, Internet Information Technology firms. What's the goal of the mouse? To increase access. And during this period, what characterized the mouse? The mouse was smaller, the mouse was weaker, and the mouse had fewer resources. So this kind of sets you up for the chase. So what these parties engaged in at very first was horizontal form shifting, where I left you with the collective action problem. The genius of the rights owners in the United States was to define intellectual property as a trade issue. It had been here in the World Intellectual Property Organization. World Intellectual Property Organization had no enforcement powers, so they weren't really getting satisfaction through the World Intellectual Property Organization. So let's talk about the trade consequences of intellectual property. Let's think of it as a trade problem. So by defining it as a trade problem, it was a strategic move. It enabled them to enlist new partners, new coalition partners, and activate new institutions in the pursuit of their goals. So by defining it as a trade issue, they were able to get Congress and the executive branch behind it, as well as the United States Trade Representative's Office. And they were also able to mobilize a new set of institutions, which were the trade institutions. So in 1986, the General Agreement on Trade and Tariffs, the CATs had already convinced the United States government to adopt different domestic policies and trade reform policies that would make intellectual property protection a core part of US trade policy and domestic trade policy. But now they thought, well, let's see how we do it at the multilateral level. Let's really try to get a multilateral agreement on intellectual property. And so they were able to inject it into the General Agreement on Trade and Tariffs in 1986 when they started the Uruguay round of trade negotiations. So suddenly intellectual property was brought specifically into the trade regime by the process of their framing it as a trade issue and persuading important government actors that this was an acceptable and useful way to think about intellectual property. So what happened in the negotiations for intellectual property, it resulted in the Agreement on Trade-Related Intellectual Property Rights. And during the process of negotiations from 1986 to 1994, GATT was subsumed into the World Trade Organization, which has a very robust enforcement mechanism. It's hard law, it's binding. Everyone who signed up for WTO had to abide by TRIPS. It required them to adopt intellectual property protections that many of the countries didn't have. For poor countries, they had grandfathering, they had transition periods that could maybe be extended. But basically, this was the most comprehensive international intellectual property agreement ever. It was binding and it was enforceable, unlike anything in WIPO, which was not enforceable. So there were real consequences if you were to violate a member state's intellectual property. So this was a big victory for the CAD. This was a huge deal. The representatives of the CAD at the time said we got 95% of what we wanted. Meanwhile, in about the late 1990s and early 2000s, the HIV/AIDS pandemic hit sub-Saharan Africa like a lightning bolt. And AIDS activists in the United States, worldwide, in South Africa, the Treatment Access Campaign, there was a lot of activism around access to HIV/AIDS medications. The price of these drugs was $10,000 for a treatment for HIV/AIDS, and there were a lot of people dying because they couldn't get a hold of the drugs affordably. And so what Jerry did, Jerry went over to the World Health Organization and reframed intellectual property protection as a public health issue, because the patents on the drugs were making the prices so high that people, they argue, were dying unnecessarily because they can't get a hold of the drugs. And so in the WHO, the World Health Assembly in 1999, they came up with a recommendation that nothing in a trade agreement should compromise the ability of governments to be able to provide public health for their people. And this was a unanimous resolution, soft law, declaration. It's the World Health Organization. But this was another example of framing an issue as something, not a trade issue, but a public health issue in the wake of this crisis that allowed them to activate a different multilateral organization in order to reconceptualize the issue. And then what Jerry was able to do was bring it back into the World Trade Organization. And this resulted in, so they cooked up an alternative approach to trade in the WHO and then shifted horizontally back into the WTO and came up with the Doha Declaration on TRIPS and Public Health, 2001, which really didn't say anything that was not already in TRIPS, but it did reaffirm states, countries' rights to look after public health, even if it meant not pleasing the pharmaceutical firms, so that they could still look after public health. Because between 1996 and 2001, they were getting a lot of bilateral pressure. They were getting bullied a lot about when they try to take steps that were consistent with TRIPS, like compulsory licensing a drug, for example. They were getting a lot of pushback from the United States and from pharma firms. Bill Clinton sued Nelson Mandela. It was a really, really proud moment. So on behalf of pharma. So, they were getting all this pressure, and the reason they went here is they wanted a declaration. They wanted to just lay it out there, clarify that you should stop bullying us because we have the right to do this. So this is when Jerry was able to use framing and strategic shifting of institutions in order to get clarification of what the mouse was able to get under this situation. So, and this led to another, the only amendment that's been made to TRIPS in 2003, which is the paragraph 6 amendments, which involved a country that doesn't have generic capacity, they don't have the capacity to make generic drugs, that under a compulsory license from another country, if they issue a compulsory license, they could import those drugs and produce the, have them available to their population. But in reality, this was hailed as a big victory on the day that it was signed, but in reality, the provisions are so complicated. It's only ever been used once by a Canadian generics firm to provide drugs to Rwanda, and the process is so convoluted, they said, never again are we going to use this. This is really not very user-friendly. But at any rate, it was another example of the health framing changing something in the regulation. So at this point, Tom knows it's too politically hot to try to get higher standards of intellectual property protection through the WTO process. The public health thing has everyone talking about it. They're not going to accept any higher norms for intellectual property protection or enforcement. So we're going to tiptoe back over to the World Intellectual Property Organization, which has been a more friendly, assuming it's a more friendly environment at this point. And they wanted to resuscitate old negotiations that were the substantive patent law harmonization treaty negotiations that would harmonize patent laws at a TRIPS plus at a higher standard of protection. But the cats, or the mice were over at WIPO, and they remembered what happened in WTO. They remembered what happened with the health issues and the fact that they weren't able to get medicines. And so in this case, the cat was rebuffed. Developing countries said, no, we're not going to agree to this. We agreed to all these things you wanted in the Uruguay round. You promised us market access for agriculture. You promised us in exchange for protecting intellectual property that you would phase out your textile protection, which they did. They did the latter, but they did not make good on the promise to open up their market access for agricultural goods. And so there was a lot of distrust and bad blood at the end of this. It's like, we've done all these things you've asked us to do. It's very costly. You have not come through on your promises, so we're not going to talk about higher standards until you make good on your promises. So then they countered with a development agenda. So the developing countries proposed a development agenda. You know, we gave you what you wanted in intellectual property. Now let's talk about development issues like technology transfer, limitations and exceptions to copyright. So the developing countries proposed this in 2004. The United States was very opposed, saying, WIPO, you're not a development agency. You have no business doing this. By 2006, Jerry had rejected any kind of substantive patent law harmonization negotiations. Those were dead in the water. They said, we're not going to talk about anything you want here until you take the development agenda seriously. So this was finally adopted in 2007, a development agenda to take into account the needs and concerns of developing countries. And what happened then is Jerry really chased Tom back out of the World Intellectual Property Organization. That was the result, because Jerry rebuffed the cat's efforts, rebuffed Tom's efforts. So here's the WIPO development agenda adopted in 2007. Just 3 weeks after the development of, or the adoption of that, the United States Trade Representative, the European Community, and Japan announced their intention to pursue a plurilateral anti-counterfeiting trade agreement, and Trans-Pacific Partnership, also another example of this plurilateral approach. So they shifted forums vertically rather than the horizontal multilateral shifting that we saw back and forth between the cat and mouse. Now the cat got chased out of WIPO on this issue and said, we're going to do a plurilateral agreement with like-minded parties in order to get a higher standard that we know we could never get multilaterally, especially after the HIV/AIDS thing. And so we ended up with a plurilateral move towards anti-counterfeiting trade agreement. So now the big shift was towards vertical forum shifting. And I'll just show you how this works. We have the multilateral level, which is the horizontal I was talking about, where you go back and forth from WIPO to, you know, acronym HELL, which is where I live. You're just back from Washington. You're familiar with all the alphabet soup. But the multilateral level, the WIPO development agenda led Tom to go plurilateral with anti-counterfeiting trade agreement, Trans-Pacific Partnership, Transatlantic Trade and Investment Partnership. Regional, vertical shifting, regional, we have NAFTA and CAFTA as just two examples, North American Free Trade Agreement and Central American Free Trade Agreement and Dominican Republic. The bilateral, the European Union Economic Partnership Agreements, US Free Trade Agreements, which you have a ton of those, and then unilateral, the United States Trade Representatives 301 process, whereas the naming and shaming of who's not supporting our intellectual property rights. And then unilateral domestic law, Stop Online Piracy Act, and Protect Intellectual Property Act, which I'll be talking about in a minute. Now, generally, vertical forum shifting occurs when there is a smaller group of states that has very intense interest in an issue, and will shift vertically when it can leverage asymmetrical power to get the result that it wants. And that's what we have seen in intellectual property since the multilateral stalemate that I've described through the horizontal shifting. So it's used by powerful states whose vital interests are at stake and where their position on issues is very different than the majority of the rest of the states. And that's what we're seeing with the United States strategy promoted by these firms. So then I want to move on to Anti-Counterfeiting Trade Act. The Anti-Counterfeiting Trade Act was designed to, it was really aimed at pirate websites, what they call pirate websites. And part of the argument was that, yeah, we've got TRIPS now, we've got bilateral deals, but what we're not seeing is enforcement. So they really wanted to focus on an anti-counterfeiting agreement that would deal with enforcement and also deal with the digital world, because there was no, everybody wasn't on the internet in 1994 when TRIPS was agreed to, so they felt like they had to do something about the digital environment. And so they shifted vertically to try to get a counterfeit enforcement treaty. Back one more. And it was aimed at, ACTA was aimed at foreign websites like Pirate Bay. And the idea was to block Americans from accessing websites that foreign websites that host infringing content. So they were trying to get credit card companies and companies like PayPal to refuse to process, to forbid them to process payments from Americans to these pirate websites, and block access of Americans to those websites as well. So it's a form of censorship, but it was censorship on the part of content owners rather than, for political reasons. And so this was the target, the European pirate parties and their websites. And at the same time, while they were negotiating the anti-counterfeiting trade agreement, they were negotiating domestic laws addressing the same issues called the Stop Online Piracy Act and Protect Intellectual Property Act. These, again, were aimed at foreign pirate sites that host infringing content. And it was a domestic law that had foreign targets. So that was the idea. So similar to some of the provisions in ACTA. What happened in this case was really interesting. This is my Revenge of the Nerds piece. U.S. domestic politics, which we find in intellectual property in particular, is that the USTR and the U.S. Trade Representatives Policy Advisory Group, they are a very cozy group. Who's invited? Consumers are not invited to consult with USTR. It's not underneath the Administrative Procedures Act, so they don't have to do notice and comment because it's foreign trade, it's a security issue. And so what we've gotten is a real revolving door between Congress and between intellectual property rights owners in USTR. And here's an example of Christopher Dodd, Chairman and Chief Executive Officer of the Motion Picture Association of America, former USTR Mickey Cantor is a lobbyist for pharma now. So there's a really quite a bit of data on the revolving door between USTR and rights holders industry. So there's a symbiotic relationship, a revolving door, and they have institutional direct representation to USTR that the rest of us don't have. And the expectation on the part of these people is that they're going to get their way. They usually do. They had gotten it ever since the 70s when they were getting all these new laws passed and getting governmental buy-in for increasing intellectual property protection both at home and abroad. But something happened, and this is U.S. domestic politics. Unlike trade policy making, it's transparent. It's open. There were hearings in Congress. It was a democratic process. And the late Aaron Swartz started to mobilize people online. And there was a lot of concern of users that this Stop Online Piracy Act and Protect Intellectual Property Act were going to hurt privacy, that they were going to amount to censorship, they were going to deny free speech rights under the First Amendment. So there was a lot of online mobilization, but there was also offline mobilization. And in Congress, the anti-SOPA-PIPA people were the ones who knew something about how the internet worked. And shockingly, very few of them did, but Ron Wyden of Oregon was one who had written safe harbor provisions for ISP internet service providers, so he was knowledgeable. Jared Paulus had been a tech entrepreneur in Boulder. Zoe Lofgren, representing Silicon Valley, they actually knew how the internet worked, and they made fairly strong speeches against these laws that they were going to disrupt the stability of the internet and that this was not a good way to go. And so the online mobilization and offline in Congress combined together. It was a hybrid transnational network. A lot of Europeans were involved too. And a bunch of websites agreed that they were going to have a big blackout to just let people know the palpable result of what this would mean if these laws passed. And so Talking Points Memo, which is a really important blog, Reddit, user uploading service, January 10th of 2012, the bills were about to be voted on, or what one of them was. So they said, we're going to go dark. January 11th, 12th was Destructoic and Icon has Cheeseburger. Boing Boing, which is Cory Doctorow's really important blog, announced January 14th, we're going to go dark. Mozilla, they got hundreds, thousands of websites to agree to go dark. Move On, which is a campaign finance reform group. This Wikipedia, which my students would die without, I think. So anyway, they said, we're going to plan to go dark. And so on January 12th of, January 18th, Wikipedia decided to do a blackout. They agreed, they got Democratic buy-in from their members, and they said, yes, do a blackout. And then the day of January 18th, 2012, everybody woke up to get in Wikipedia to write papers for my class or whatever, and this is what they saw. And it was a very powerful statement of a palpable statement of what the protesters felt was at stake. Imagine a world with no knowledge. They're trying to censor the internet for Hollywood. This is bad for free speech, all the rest of it. But this was a shocking and very effective way to get their message across. I saw some of you in the back nodding your heads. Yeah, you remember, you had a paper due that day too, didn't you? Yeah. So as a result, the bill was dead, January 18th, 2012, and there's some pretty neat graphics that you can find of how quickly the support went away after the blackout. It was very, very important. About 5 days afterwards, the Polish parliament voted against, Anonymous. I'm sorry, Anonymous was also very involved in this. These masks are Guy Fawkes masks. Was a prankster, English prankster, but the copyright for this image is owned by Warner Brothers. And the reason Anonymous has adopted this is because every time you use this image, you're supposed to pay Warner Brothers money. Well, they don't, but that's why they adopted this thing. And then they were leaking all this like embarrassing personal information about movie studio executives. And they do a lot of disruptive pranksterish stuff, but they were very involved in this. And then a few days after the the Congress backed away and the bills were dead, the Polish parliament came out. But what happened in the United States, and this is what's so interesting, was so different, what happened domestically in the United States in an open democratic process sparked protest abroad. It's like, oh my God, the Americans are voting against something the rights holders want? This is a first. And it sparked a lot of protest in Europe. Just several days after it went down in the United States, this is a Polish parliament protesting ACTA. They all came in their Guy Fawkes masks. And then on February 11th, 2012, hundreds of thousands of people took to the streets. These are all the cities where there were marches, protests, old-style politics, people out there protesting ACTA in over 200 European cities. Poland, Germany, Latvia, Czech Republic, Slovakia, Lithuania, they all rejected ACTA. I think it might have been the Slovakian negotiator actually apologized to her children for ever having signed the agreement on this day. And in July 2012, the European Parliament voted against ACTA, 478 to 39. So 22 of 27 EU member states cannot ratify ACTA. So this was a really interesting dynamic of bottom-up protests, online and offline, really undoing U.S. economic foreign policy, which we've been imposing top-down consistently since, at least since TRIPS. And this was a disruptive one, and that's what made it so interesting. And the rights holders were absolutely flabbergasted. It hadn't happened before. They're like, oh, that democratic process, not good. And so now we have the Trans-Pacific Partnership. Same kind of thing, same kind of plurilateral effort. And this is not a very good map, but this is a pretty crazy, why these countries? And then there's Morocco. I guess it didn't make it on the map, but it's kind of a hodgepodge of countries, most of whom are already yoked to a higher standard of intellectual property protection, which is one of the reasons for including this sort of hodgepodge of countries. Now, the interesting thing about Trans-Pacific Partnership is it's asking for many stronger protections of intellectual property than are available in TRIPS. And the basic logic behind ACTA and TPP, the US and rights holders know there's no way that they can get what they want in an open multilateral setting. That's off the table. WTO is no good for them. WIPO is no good for them anymore in terms of getting higher standards, or reducing flexibilities. So they've been using vertical form shifting. And this is the latest plurilateral effort to try to gain an advantage. And the interesting thing about this is the countries that US and its rights holders are really concerned about, none of them are at the table. There's no China, there's no India, there's no Brazil. I don't think any of the rights holders lose sleep over Morocco. I'm sorry, I'm sure it's a beautiful country, but that's not the biggest market of the future. There's no South Africa, there's no Brazil, there's no Argentina. Some of the countries that have pushed the development agenda, some of the countries that are not so keen on more and more protections. And so they're not there. So why is the US doing this with this kind of crazy hodgepodge of countries? The strategy is, if we can get a TPP with really strong TRIPS plus intellectual property protections, that's 40% of the world economy. And if we can get the Transatlantic Trade and Investment Partnership with high standards, that's 80% of the world economy. Then the countries we're really concerned about, India, China, Brazil, the strategy is this. They will have no choice but to sign on to these higher standards.
Just one thing, to clarify, Japan is on the map. But
oh, I know this map is totally not complete, and it's really blurry, too.
Why that much of the economy is involved?
Yeah, it's not Chile and Peru.
Very, very big country that isn't on that map.
Yeah, thank you. Yeah, I need a better picture. It's clear. But yeah, Japan's kind of an important country there. So anyway, and Morocco's not on there either, but it's not quite as large of a percentage. So at any rate, Trans-Pacific and Canada, Mexico, I mean, there's more. This is a really bad map, actually. So, but at any rate, that's the strategic game they're playing. And so that's what the US is trying to do. Looks like they got a victory today, but there'll be really interesting pushback from the MICE and from the SOPA PIPA protesters in the next, the congressional fight that's to come. Many people involved in the anti-ACTA protests were drawing parallels between and hoping it would be contagious to the Trans-Pacific Partnership. And there are a lot of protesters, of course, in all the TPP meetings. You can see these same kind of signs that we saw for TRIPS and ACTA, are also, here in the end secrecy of TPP. So there's a couple different questions I'll just close with, but that's the big strategic picture, and that's what I'm trying to map out. I know cat and mouse is too oversimplified, but there's so many moving parts in different institutions. I think they're pretty useful guides in going through all this dynamic moving process. But are we going to see continued conflict over property rights this way between those who want really stronger rights and no flexibilities and those that need flexibilities and more access? So there's the continued conflict model. I think this is a bit how Tom's feeling today, to be honest, but I haven't seen all the details yet. Will there be peaceful coexistence? Any kind of creative engagement that might engage the legitimate interests of countries that can't afford to buy the stuff at full price? Or will there be strategic withdrawal? I talked to a Chinese a copyright lawyer who helped draft Chinese copyright law. And I said, what are you going to do if TPP goes through? And she said, why should we care? You know, we're going to do what we're going to do. But not everyone in China is of that mind. There's a lot of very pro-property rights, IP property rights people in China who aren't Chinese, so that's a real mixed bag. But will these larger countries, the emerging economies, the emerging markets, really be able to ignore some of the provisions in here by not signing on to it? I think that's a really important question. So just to summarize in terms of the you know, what motivated this project, I just want to highlight that it's a process ontology. We have to look at the process and how this framing, it's really a continual set of negotiations. It's not one and it's over. And each iteration of the process changes the game yet again through framing, strategic behavior on the part of the actors, and their ability to mobilize new coalitions and new institutions. I also would argue that the procedural and substantive legitimacy are inseparable. Was a process fair? Were we included? Did we have a voice? Are these kind of laws really good for us, for our economies? And a lot of the post-TRIPS activity is always about getting better enforcement. But if these agreements are seen as kind of illegitimate, or if they're seen as very damaging or negative for countries, why should you expect enforcement? So I think we really need to focus on the process. We need to focus on the legitimacy of both the process itself and the substance of what those laws are. So the form of cooperation matters, and in my field, they're kind of overly, in my view, obsessed with the form of cooperation, but I think the substance matters too. All the institutional design stuff, I mean, it's had a good contribution, but if you ignore the substance, you're really missing a lot of the contestation and a lot of the politics. So the core question is, you know, who benefits? And I would argue that the distributive consequences are paramount and help to explain this continued contestation over these issues. And that's it.
Okay, is this on? No?
Yeah, it's on.
Oh, well, now it's more on. That's not the right word. It is more thoroughly on, or whatever. Thank you very much, Susan. And now we have time for about a half hour for questions and comments and discussion. And because we're recording this, we want to be able to record your questions. So if you raise your hand, I'll bring you the microphone, and you can ask your question.
Sue Helper, thanks a lot. It's really interesting. I had two questions. I guess one is, to the extent you know, I guess, what's in TPP that's not in TRIPS in terms of intellectual property rights? And then I guess the second one is, it seems like there are different people with, say, even within the U.S., different kinds of intellectual property rights issues. So we have Disney and Mickey Mouse. And then we also have, say, the small manufacturer that, you know, has their product that they've painfully developed, and now they find their Chinese partner is, you know, making it and exporting it back at a lower price or undercutting them. Are these sort of the same problem? Are they different problems? Are there policies that would, you know, affect one, not the other? Whatever you want to, however you want to take that one. Thank you.
Okay, so some of the things, since the only, and this is a sad statement, and I think there needs to be a little more sunlight in the USTR, the only versions of the agreement I've seen have come from WikiLeaks. You know, the secrecy has been pretty much unprecedented in terms of a trade agreement, no matter what they say. This has been really quite extreme. And so, but what I understand is in TPP, and one of the big things was, and today I don't have a full reading of all the things that happened today, but one of the really big differences of TPP is to require all the signatories to offer data exclusivity for biologic drugs. And the administration was asking for a 12-year period. And the idea of having data exclusivity means, you know, when you are applying for your regulatory approval for your biologic drugs, and those are the drugs they might derive from cells to make a boutique one to target your particular cancer cells, or they're, you know, sophisticated new drugs, these biologics. And so the makers of them wanted to have more protection. And so what they wanted was 12 years of data exclusivity. And that means if I'm a generic maker, I can't have access to their clinical trial data for 12 years, if that's what it is. And then only then could I have access to that data and then develop something that I would call a biosimilar that I could prove was I could show that was biosimilar to the biologic drug to get regulatory approval for my generic competitor. What the pharmaceutical firms have been trying to do by expanding these rights, which are on top of independent of patent rights, of data exclusivity, is to try to forestall entry of generic competition, but also to try to get generics firms to do their own clinical trials. And there's a lot of medical ethics questions about that. If you can prove biosimilarity, it's not ethical to run experiments on human beings that have already been proven to work. And so it's been seen as a big assault on the generic competition in the next generation of drugs. So that's one of the big controversies around it. There are a lot of other provisions that are designed to stall generic competition, things like patent linkage, and there's a lot of really technical things in there. I'm not sure if they survived or not. The latest news I got today was, because they're just releasing kind of the top headline things, so I don't know if patent linkage showed up, and where in order to approve a generic drug, they have to get a permission from the patent owner. They're adding all these new conditions to try and make it harder for a generic to enter the market. But one of the big headline stories is that Australia, which is very concerned about a 12-year data exclusivity period, because every year of data exclusivity, the Australians argued would cost us, our health plan, $100 million more a year. So they wanted to crunch it back. And it sounds like the Australians didn't blink, and they held it to a 5-year data exclusivity, which some countries already have. But there's something floating around called a 5+3. And if there's a 5+3, you know that pharma's going to keep pushing for the 8. And Obama administration was asking for 7 in its own budget, but somehow USTR was asking for 12. But it will make it harder to get access to generic drugs, those parts of it. In terms of, yes, there are different interests, and my sense of things was that the copyright, people didn't get everything they wanted, so this might be better for firms like Google or ISP, internet service providers. There was some pushing back there, but again, I don't have the details in front of me. But there are a lot of different positions within the United States. There's on intellectual property, but the ones that have the most resources are the big ones that are pushing for more rights and stronger rights. Google has been sort of, some people with the Revenge of the Nerds story said, oh, that was just a story about big companies against big companies. It was this Google versus Hollywood, which the empirics of that's simply not true. Google came very late to the party. It was people like Aaron Swartz and Ron Wyden who'd been working on these issues for a long time. And in fact, during the hearings on SOPA-PIPA, the Google lawyer was there, and they just crucified her. The Congress did. And they were bragging about they don't know anything about the internet, but we're going to pass this 100-page bill. One of the guys on the Science and Technology Committee or whatever committee said, I'm not a nerd. I don't know how the internet works. That's where Revenge of the Nerds came from, because it's it's kind of good to know how those interwebs work if you're going to be regulating it. But at any rate, so there's a lot of different opinions, but and Google now is a player, and it is pushing back more than it did. But one of the trends that I think is very concerning in the wake of this little democratic Revenge of the Nerds with the open process and stuff is what internet service providers and content producers, Hollywood and TV and all that stuff, are now entering into private contracts. So they're engaging in private ordering through private contract, which cuts out the politicians, it cuts out the Congress, but it also cuts out the users. And that's why, and also some of the, Viacom, Comcast, and that's why sometimes you're able to watch something on Netflix and then it suddenly disappears. So, and those are private contracts. We can't see what they are. They don't have to report them. And then the other really concerning thing, and I don't know how this one came out, but this is a really important one to watch for, because I think it's a very dangerous piece of TPP, and it's the investor-state dispute settlement provisions. There's 3 cases right now that I think are really important because they're the first investor-state dispute settlement provisions that have an intellectual property logic behind them. These are a brand new area of trying to use these provisions. Now, traditionally, investor-state dispute settlement provisions, what it means, ISDS, it means I'm a private investor. I've invested in some country in Latin America. I'm a private copper company, and I've invested in Latin America, and they nationalize my copper mine. Well, they expropriate it. What's my recourse? And maybe their rule of law isn't as good as ours. So the ISDS were to protect inventors so that I would be able to directly, as Anaconda Copper or whatever, I could directly sue Chile for compensation for the loss of my expected investment. Okay, and that's what it was designed for. Places that didn't have good rule of law, places where after decolonization in particular, expropriation was a pretty common thing, especially in the natural resource extraction business. And that was the origins of ISDS, or not a good rule of law and stuff like that. So an investor can directly sue a government. But now under NAFTA, I'll talk about the Eli Lilly case briefly, North American Free Trade Agreement, we have investor-state dispute settlement provisions. The U.S. insisted upon them for Canada, Mexico, and us. And so what Eli Lilly is doing now, Canada has a very robust public health system, very committed to keeping costs low. It has a high standard of granting patents. They don't like patents for Me Too drugs or for second uses of a known compound. If you have some drug for antacid, and then you find out it helps with women's facial hair. They don't want a new patent for that thing. There's all these crazy stories, but it's called the new use of a known product. So they don't want to give patents to that stuff to keep costs low. And so the Supreme Court in Canada, Canadian Court, Appellate Court, and then the Supreme Court of Canada backed the invalidation of 2 patents that Eli Lilly tried to get. They filed for the patents, and then the Canadian court said, no, these don't really hit our standard. They don't make our standard. You didn't provide the evidence you need to have this really be patented. So they were invalidated. So now Eli Lilly is suing under ISDS, the government of Canada, saying that we did not get the expected value of our investment at the time because you've invalidated our patents. They're suing for $500 million just to protect, just to defend itself. So far, the Canadian government spent $35 million just to defend itself in these suits. So you imagine how powerful these measures are when you're going after a small, weak country. So, but the interesting thing about this is an intellectual property. It's our patents. That's the investment. That's the asset that we invested in your country. And now we're not getting so it's a new broadening of what an investment asset is. The second cases are about plain packaging of tobacco. Those are intellectual property cases as well. They're trademark cases. So in Uruguay and in Australia, they're being sued under ISDS provisions in various bilateral agreements that they have. I think it's an Australia-Singapore ISDS one, if I'm not mistaken. Philip Morris in London tiptoed over to Singapore and established some offices there right before filing the ISDS action against Australia for plain packaging. Plain packaging is a public health policy where, you on the cigarette package, you'll have someone with a big hole in their throat or like an infected lung or John Oliver has a really great piece on it. You should look up tobacco. Or the toe with the corpse tag on it in the morgue. And then in little letters, they'll say Marlboro. And so Philip Morris is saying, hey, I'm not getting the expected value of my investment. When I invested here, I got to have the cowboy and the big red and white Marlboro letters all over the place. So the expected return on my investment I'm not realizing that. So I'm suing you for that. And then in Uruguay, Philip Morris is also might be British American Tobacco, but they're suing Uruguay for the same thing. And guess who's paying for the Uruguay government defense is Michael Bloomberg. So, but the very dangerous thing I think about these ISDS is intellectual property. It's really a case of the camel's nose inside the tent. Because you can only imagine, like if they get intellectual property recognized is actionable as an investment asset, that there's just going to be a huge explosion of cases that are really going to challenge states' abilities to adopt public health policies or even environmental policies. What if I'm a fracking company and I have invested somewhere and I'm fracking my brains out there and making a nice amount of money, and then people are like, oh, earthquake suddenly. Maybe we don't want this. And then there's a law saying no more fracking. They could be sued under ISDS privileges or under those provisions. So it's a very important, and it's ISDS, the eyes glaze over and stuff, but it's a really important thing to pay attention to because it's going to affect a lot of us if this gets really widespread.
Questions? Other people? Oh, you don't need this recorded. There is stuff in the back if you want to get a drink or bite to eat. And you're next, okay?
Thanks, Susan, for such an interesting talk. I wanted to ask, you talk a lot about the framing and reframing. Along with those frames are competing claims. And I'm just wondering, over time, do we ever end debates over competing claims? Like I remember in some of your earlier work, you produced some evidence that this idea that pharma couldn't innovate unless they had strong IP, that sort of stuff. I'm just wondering where we are with that. Do we ever end the competing claims, or does over time it just repeats itself with new frames, or do you leave it behind?
Well, it's really fascinating because there's been a lot of criticism. I mean, economists of innovation have been criticizing very much. Even Obama, after the crisis, the 2008 crisis, he says there's a big problem with big pharma. It's not innovating anymore. And, we've got intellectual property rights that are this high, but somehow the innovation is going in the wrong direction. They don't have the new molecules. They don't have, And so he took $1 billion and gave it to, in tight economic times, he gave it to NIH to innovate new drugs. So there's some evidence that, the correlation isn't there. They don't want to be transparent about their pricing. How much taxpayer money went into the development of those drugs, which is usually a lot, meaning NIH research, but they capture the full rents. The taxpayers don't get any of that back. So there's a lot of discussions now, and I think it's a really interesting moment in the United States, talking, first with the Hep C drug, $80,000 shot. There's also a cancer drug for, I think, small cell lung cancer that is $150,000, and it's been shown to prolong your life by 3.2 months. The Veterans Administration, AARP, have all come out very concerned about the drug prices. They're like, you're going to bankrupt our system. And a lot of vets have Hep C, and we can't pay these prices. And so they're trying to negotiate lower prices. And the pharmaceutical companies keep saying, well, we want transparency of the regulatory process. In all these countries, we want transparency of how you set your formulary prices. What you're going to charge, $19 a pill versus $1,000. But I think we need to ask them to be transparent about their pricing models. And even though there's been good empirical evidence that questions their claims about the relationship between high standard of intellectual property protection and innovation, the talking points haven't changed since the 1970s. All that's changed is the amount of money that they say it costs. It's gone from $500 million to $1 billion. I think it's up to $2 billion. They just pull these numbers out of a hat without showing any methodology, and they get in all the public discourse. Well, a lot of blockbuster drugs, like we had 100 that didn't work. It's $2 billion to get a drug, all the way from laboratory to market. But, we need to know the marketing costs. They definitely, and clinical trial costs, but they don't want to be transparent about it because they make up the numbers. And I'm not being like a paranoid, crazy person saying that.
No, you're not.
They really do.
They make up the numbers.
And they never change. Like, every 5 years it goes up about $500 million. It's just quite astonishing. So in the political discourse, it's there and it's stuck. So independent of what evidence has come out since then, this is what the congressmen say, this is what all the talking points, it's always the same. We need it, we're innovation, we're saving lives, we're doing this, we're doing that, and it costs $2 billion, and that's why we have to charge $80,000 for, that's the game. And in fact, there was a very interesting GAO report that came out, and it was about And they don't have any skin in the game. I mean, they're supposed to be very objective and stuff. And Congress had asked the GAO, they said, could you come up with some numbers? Because Hollywood was like, we want more, we want more, we want more protection. And they said, could you come up with some numbers of how much money the American economy loses every year by copyright piracy, you know, to use in Congress and stuff? So these economists did the math, and their report came out and said, actually, we can't say you're losing money, because the money people, it's, you know, when you're buying, you know, you go to the Foggy Bottom Metro and you buy the Lion King, you know you're not getting the Disney version, right? You're getting some camcorder version with Russian subtitles. You know that, you know, that's why it's $2. So they said, but we can't say the economy is losing all this money, because the money they're not spending on the $39 version of the Lion King, they're investing in our economy. They're buying groceries, they're buying gasoline, they're buying, you know, education. So the money's getting recirculated into the economy. So you can't say that the amount they didn't spend for it is all loss for the American economy, which is what they claim. And so I asked the USTR, I said, well, gosh, you know, what about the GAO study? Kind of raised some questions about the data, you know, that they claim to make their political asks, and they said, oh, we don't pay any attention to it. Revolving door, I'm just saying, campaign finance reform, be a good idea. Because these issues are also totally bipartisan. It's not Democratic, it's not Republican. They all have supported stronger IP for the get-go. And Bill Clinton sued Nelson Mandela. I mean, get your mind around that.
By the way,
Right.
it should be pointed out that most of the development of the AIDS drugs was done by NIH.
Well, that's absolutely true. That's why ACT UP went crazy here, you know.
Just a couple of questions. Are these patents are these patents in the US and Europe validated by any kind of agency? Because a European patent may partially overlap a US patent. How do they resolve this during negotiations, these kind of issues?
Through litigation.
But zillions of patents. I mean, essentially, who is looking after that? When a U.S. patent is, there's an application for a U.S. patent, there's a process of 2 years to do search and all that. The same thing in Europe. But they don't cross-correlate, okay, so far as I know. So you may have competing patents there, and how is this resolved?
Well, actually,
when it appears somewhere that there's a conflict, then they resolve it?
No, there was more conflict about that in the past. But because the United States had a position that I think they changed this with TRIPS, but the U.S. position saying, you know, who's the first comer? Who's the first person who invented that? We used to have a first to invent law. Our rule is first to invent. So whoever invented it first got the patent. Whereas the rest of the world had a first to file process. And the United States now has adopted first to file, because there were a lot of conflicts over that. Well, I filed it, you know, I invented it to prove I invented it first, but I filed it, you know, 2 months after you say you invented it. So there were a lot of conflicts between Europeans and the US in terms of who had the right of priority. But now the US is harmonized so everyone's first to file now.
First to file?
Yes. So that's removed that conflict.
And this is a general rule only for Europe and the US? How about Canada or other countries?
No, we were the outlier. First to invent, we were the only ones that had that. That was a weirdo thing the US had. But now everybody's first to file.
First to file?
Yeah.
Okay.
So that's eliminated that kind of conflict. And then if someone thinks, you know, a US maker is violating their patent, you know, European person that owns the patent, they will litigate. That's...
Yeah. Another simple question. I mean, are these intellectual property rights of the movie industry, etc., covered by copyright, or
Yes.
because
Copyright.
patent doesn't apply here?
No, it's copyright. That's all about copyright.
Okay.
And and the United States has, I think, death of the author plus 90 years. The Sonny Bono Copyright Extension Act. For copyright.
Not for everything. I think not for articles. It's 75 years, isn't it?
This was called the Mickey Mouse Patent Act. Mickey Mouse was about to
So it's a different copyright law
expire.
for them?
I'm not sure about articles. You mean a
I
journal
think it's
article?
75 years.
75? I think it's
thought so,
90.
yeah.
Death of the author plus 90 for that. I think that was the Disney term that they got. But Mickey Mouse was about to expire, and so Disney said we want longer, and Sonny Bono lobbied for that, and that's what the U.S. went for. But I'm not sure what the term, you know, I don't know what the copyright bits look like in TPP. There are things that were concerning to people, things that had a bit of the whiff of ACTA in them, but I've not seen, recent drafts or updated. And from the little bits I got from all the blogs I'm on and stuff, it sounded like there was a bit of relief in the tech community, but I'm not sure what was decided. So it might not have been as bad.
Anybody else have a question? I will ask one then. What's in this for the Japanese? Why are why the Japanese are the other really big economy in the TPP?
Autos.
Autos.
Yeah. See, unlike this is interesting because unlike ACTA, which was not a trade agreement, it was an intellectual property agreement about the digital realm and enforcement. TPP is a trade agreement. Most of the easy stuff we've taken care of, the border stuff, but there are a few real trade issues there. There was dairy, there's auto, and rice, I think, too. But Japan got something it wanted, which is more access to our markets. Over 25 years for cars and 30 years for trucks. They'll be able to import more, I guess, from there. But that's partly in it for Japan. But Japan, there's also a big strategic story to be told about the TPP and Obama's pivot to Asia, and that's to try to contain the growing power of China. And the U.S. wants to keep a big footprint in Asia and not be locked out with regional agreements that keep the U.S. out. And so his pivot to Asia is really about geostrategic interests and also reassuring Japan that America's still there for them on some level and won't let China, to calm Japan down a little bit because there's been a lot of nasty back and forth between Japan and China. And also a hedge against regional agreements that will cut the U.S. out. The U.S. really screwed up when it refused to recognize the Asian Infrastructure and Investment Bank that was set up by the Chinese. They were at the forefront of it. Obama even told all our allies not to support it. It's like an Asian World Bank, basically. They said to all our allies, don't support it, don't support it. I think the day after the thing was signed, Germany and England were like, yeah, we're all for it. So that was kind of egg on Obama's face, and I think he's going to find a way to tiptoe back and recognize it or acknowledge it. But that was kind of stupid. If you wanted to have a footprint in Asia, should at least recognize that. But yeah, you stood alone on that one.
One last question and no last questions? That's one last question.
What are the chances that the U.S. will actually approve the TPP, and what happens if it doesn't?
Well, if it doesn't, I would be probably doing a street jig. I'd even upload that onto YouTube. But there's some interesting questions. The Republican candidates have kind of been jumping all over themselves trying to say who's going to reject it quicker. Donald Trump is like, this is a bad deal. It's a huge mistake. So there's that rhetoric. And then Mitch McConnell he's from Kentucky. He was very upset with any talk of a carve-out, and this is something I can't wait to see if it happened or not, that tobacco would be carved out of ISDS, and that we would not let Philip Morris sue Uruguay and Australia for plain packaging laws. That and Australia really wanted that. We want tobacco to be exempted from ISDS. I don't know if they prevailed on that, but then Mitch McConnell said that if tobacco is carved out of ISDS, I cannot vote in favor of this. And I think it's going to be hard for a Republican to go out on the campaign trail, except for Donald Trump, who's not going to be the nominee. I'm pretty sure about that. But, and say, I'm against free trade. And that was a weird thing. Obama kept saying, no, your babies are against free trade. It's like a lot of this agreement's not about free trade. And increasingly, it's really about domestic regulation. So that's just kind of an easy way to say bad idea. But yeah, so I'm not really sure what's going to happen. I have got a feeling it will probably pass. I think it will probably go forward. That's my hunch.
I think it's fair to say that our discussion today about intellectual property and about trade agreements is not the only discussion that is going to occur over the next year or so. I think it's also, in my mind, very fair to say that we've had a really fine discussion led by Professor Susan Sell of the George Washington University. Thank you very much.
Thank you. And thank you all for coming, being inside on this really gorgeous day. You should get back out there and get that vitamin D. It's really